Hello, and welcome to SCG Legal. Your host today is Alina Gorokhovsky. Alina is the CEO of SCG Legal. Joining her is Amy Mortimore. Amy is a partner at Clark Wilson and the co-chair of their Estates and Trusts practice group. We also have Mark Weintraub. Mark is a partner at Clark Wilson and is the co-chair of their Estates and Trusts practice group as well.
I'm excited to interview today Mark Weintraub and Amy Mortimore from Clark Wilson's Estates and Trust Group. Mark and Amy just finished authoring a 495-page British Columbia Estate Litigation Guide that provides analysis of law and gate areas, historical perspective, and useful strategic and procedural insights. Congratulations on completing such a large project. Mark, can you provide us with a bit of background on the project and why you decided to write a book?
Yes, and thank you for having us. We're delighted to be here. We really wanted to make a contribution to the profession. I think every lawyer wants to do that, and we felt a great need for a practitioner perspective in British Columbia and the rest of Canada. There's some excellent summaries and analysis of the law. There is lacking in British Columbia that perspective from a practitioner, which means sharing strategic and tactical insights. So we wanted to bring together a text which really assisted practitioners in this area. We recognized that this was a burgeoning area of law. We see practitioners coming into this area from other practice groups, and therefore we thought we could provide a useful resource to an area which really is almost an explosive mode.
With 495-page final product, Amy, can you just give us some insights onto how you tackled such a large project and how you engaged your team?
Yes, we were very fortunate here at Clark Wilson to have a 15 lawyer group that does estate and trust work. And we called on our group and on our team to help us work through all of these pieces. The first step was for Mark and I to sit down together a number of times to create a very detailed outline, identifying the chapters that we wanted to write and the pieces that we wanted to explore within each of those chapters. And we chose as best we could the areas that we think are the most common types of claims that we see. And in addition, we chose a few that were maybe less common, but areas that we think are interesting or worth developing further, and something that estate litigators should know. After we created this skeleton, this outline, we had our team, not only the lawyers, but also our students and others, work with us to help put together this book. And I will tell you, I have read a lot of cases many times in the course of this, and really am grateful to the team effort that put this book together for us.
Great. I understand the book has 16 chapters. How did you decide what to include and why?
Well, there's the well-recognized areas which probably dominate a majority of estate litigation. Issues such as variation of a will, which is permitted in British Columbia under fairly generous circumstances. Issues such as capacity and undue influence, unjust enrichment. These are all categories of the law that are most frequently encountered by practitioners. We had to decide, however, given the time frame we were operating under, as to what areas we could leave for another edition. And there were 3 or 4 areas that we would have preferred to include in the book, but we just couldn't, and we're really looking forward to including those in the next edition. We've also addressed some of what we think are going to be the more innovative, creative approaches to dealing with certain issues in wills and estates, and we've adverted to those either in different chapters or actually focused on them in separate chapters.
I understand that in British Columbia, there's some very unique elements of this practice of law. Amy, can you just provide us with an overview of why you're so unique and how everything sort of functions in practice?
Well, I think for British Columbia, we had a long period, decades, where we didn't have a focus by our legislature in updating the estate laws, the statutes that relate to the work that we do. And then about 6 years ago, we had a new legislation that came in that's called the Wills, Estate and Succession Act. We call it WESA. And this was new omnibus legislation that combined a number of old statutes, and it also moved us forward to recognize things like electronic wills and brought us into sort of more the modern age, which included in its underpinnings this idea that the court should have discretion to allow the testator's wishes, we call them now will makers, but the testator's wishes to be given effect to. And one of the interesting ones, and one that I think many estate litigators, including myself, were very excited to see, is this section on, it's a dispensing provision. It's called Section 58. And what that does is it gets rid of hundreds of years of law, going back into England and coming through our whole history here in British Columbia, that required formal execution requirements of a will to be adhered to, otherwise the will was invalid. Now, with WESA, we are allowed to put a document before the court that is not executed in accordance with those requirements, and sometimes is not even signed by the will maker. And we ask the court to determine whether or not this is in fact a will. And this is an exciting provision because it really does allow us as lawyers to help our clients ensure that their loved ones actually have the document that expresses how they want to administer their estate, how they want to gift their estate, really be given effect to. And so I've had a number of these cases, and I don't know if you'd like to hear a few of them, but they are unusual circumstances.
We would definitely love to hear more of your memorable cases.
So the first one that I did actually was before there were any reported decisions. And oftentimes these ones come to us in tragic circumstances, and this case was no exception. And I had the partner of a man who had ended his own life, had in fact jumped from a local bridge here. But before he did that, he wrote in his notebook how he wanted to have his estate distributed. He did not have a formal will. And this was only days after the new legislation came into effect. And so I was able to go through the police to get that notebook, because it had been taken as part of the investigation, because it had been found in the car in which he had driven himself to the bridge in. And I took that back and took the original to court, and I asked that the court recognize this as being the testamentary wishes of the deceased, and I was able to obtain that order. And so I was really able to help my client, who was the partner who wouldn't have otherwise received a benefit from the deceased as a result of our intestacy provisions, and was able to help her obtain that order and move forward from there. So we've had that. I've had wills that were witnessed by video. So there was no person there, but it had been witnessed on video, and I had that accepted as a will. I had these little pieces of paper about this big that were on a calendar, and a deceased had written on the back of 2 of those pages her wishes on how to distribute her estate, and I had those recognized as a will. So we've had a lot of examples here that otherwise wouldn't have been possible but for this new legislation that came into effect. So it's not unique to British Columbia, but it's new for us, and it is in many of the other common law jurisdictions.
Wow, those are some very memorable matters. Mark, our member firms are not familiar with, I think, multi-jurisdictional issues in this practice, especially how they apply with assets or family members in British Columbia. Can you provide us with some of your memorable cases, some of your files and examples?
Well, there are a number of them in part because British Columbia is is home to individuals who actually own assets and have residences in other parts of the world. We have a lot of connections with, of course, Asia, but as well California and different parts of Europe. As a consequence, you end up with families who have assets in different jurisdictions. When there is a death, the issue really is what court has jurisdiction in dealing with the administration of the estate, and where does the litigation, if there is litigation, where does that ensue? So in British Columbia, there is a requirement to disclose all worldwide assets when probating a will. And that disclosure has to take place under oath. So if someone has died and there's property in British Columbia, the will is probated and disclosure takes place with respect to worldwide assets. However, the British Columbia courts are constrained in terms of making orders that will have impact, real impact in other jurisdictions. Obviously, a British Columbia judge cannot compel a court in Luxembourg or Switzerland or Japan to follow its orders. That would require taking that order to that other jurisdiction and getting some type of recognition. So we've had all kinds of cases where you have a British Columbia court opine on a particular aspect of the will, and then having to take that to another jurisdiction and trying to get recognition. What I really wanted to focus on, however, is the truly unique aspect of British Columbia litigation. I think every practitioner in this area will ultimately have to deal with different jurisdictions, but what they will be confronted with in British Columbia is something called the wills variation provisions. And Amy adverted to the fact that we had a wholesale overhaul of our wills and estates legislation, but one area that was not changed was this variation of a will. That permits a spouse, common law or formally married, same sex, to challenge a will if it is unfair or inequitable. It also permits a child, a biological child, to challenge a will if it is unfair or inequitable. Now, in different jurisdictions, there are various iterations of this type of legislation, but most of them are based upon asserting some form of dependency or financial need. And where British Columbia really stands out, I think, in the entire world with respect to this legislation is the generosity it permits spouses and children in going to court and saying this will is unfair. And imagine that. We actually have a statute that uses the language of equity and fairness. And so it has really invited a whole raft of litigation into our courts. And there's been some remarkable interpretations of our legislation which permits a variation. And what our courts have said, really the highest court of Canada, the Supreme Court of Canada, in interpreting this legislation, which has been imported into the new legislation regime untouched. What the Supreme Court of Canada has said is not only is there a legal obligation that must be fulfilled by the testator, by the will maker, to a spouse or child, similar to that legal obligation that must be fulfilled in lifetime, there is a moral obligation that actually has the force of law, and it has to be taken into account given the size of the estate. So what that means is that children and spouses can go into court and say, this will is unfair. Now, there's been a whole raft of criteria that have been developed to give some type of predictability to practitioners in dealing with how a will should be varied. But you can well imagine that this is quite startling to a number of British Columbians who are of the view that their will their decision in terms of how they want to leave their hard-earned assets can actually be upturned by a court. So what's evolved is a whole process by which testators, by which individuals are trying to avoid the will's variation provisions. And they do that through various mechanisms with the assistance of estate planners by putting assets into joint ownership or setting up trusts. And the reason that's important is that our legislation only addresses assets in the estate under the will. So if some asset devolves outside of the will, it's not covered by the legislation. So then you can well appreciate that we have a bit of a conundrum. You have this right under the legislation as blessed by the Supreme Court of Canada as being an important right, a legal right and a moral right. And yet there are ways of avoiding the application of that legislation. So you can end up with a very worthy candidate for an application. A child, for example, who is cognitively impaired, an adult child perhaps who was abused by a parent and who has suffered as a result, wants to challenge the will, maybe is left something, is named in the will, but there is nothing in the estate. So practitioners have struggled with how to claw back assets into the estate to really give this right an effective remedy. And we've been dealing with these types of cases for years now because we do not have anti-avoidance provisions in the statute. So what have we tried to do? One particular case that comes to mind is a group of adult children who were left nothing under their father's will. He had substantial assets, and by that I mean north of $50 million, that he had transferred to a second spouse by way of gift, deeds of gift, and joint tenancies. So they come to us and say, we have this right under the Wills Variation Act. What can you do for us? Well, what can we do? If there's nothing in the estate, we try to look for some creative approaches because we know a wrong has been committed here. We have to somehow get this out the door. So we look at, for example, was there a fraudulent conveyance? Was there an intention to avoid the Wills Variation Act? Well, that's now been established that avoiding the Wills Variation Act, or the provisions now in WESA, deliberately and with intention does not constitute a fraudulent conveyance. Well, we looked a little bit deeper, and what we found is that there was a tort that we could allege committed by the father, namely abuse of various types. And because there was not a Limitation Act issue, we were able to sue the estate for damages arising from the physical and, in one particular case, sexual abuse. We had a damages claim, therefore, and we were able to assert that the transfer of assets was for the purpose of avoiding lawful claims that our clients would have had. We had to prove, of course, the abuse took place. We had to quantify the damages, and then we had to establish that there was, in fact, the requisite intention to fraudulently set up these jointures and deeds of gift to avoid the obligations to the clients. Well, that goes only so far because the law does permit that argument to be made, but it imposes a trust on the recipient, in this particular case, the second spouse, an amount only that approximates the damages, does not claw back the entire amount to the estate. So, for example, if it was $50 million, the $50 million in assets would not revert to the estate, but there would be a claim, let's say, for the damages in $2 or $3 million. We were looking for something actually far more innovative, and we came up with a doctrine that has been referred to in a recent Supreme Court of Canada decision that our colleagues might find a little bit surprising. called a good conscience substantive constructive trust. And we were all familiar in law school with constructive trust being a remedy, but some of us may be surprised to find out that it in fact is a substantive trust that can be utilized when the conscience of the court is provoked. So we argued this as well. We said all the elements were here of using this cause of action to revert the entire amount of the transferred assets back. We had abuse, we had a deliberate contravention of the Wills Variation Act, we had the subversion of the Supreme Court of Canada's strongly stated views that there was a moral obligation to children, we had the transfer out, and we argued that this would be a violation of the court's conscience and argued constructive trust. Now, that was the good news for us as practitioners. We ultimately resolved it. The disappointing news is that the argument never actually saw the light of day in a courtroom. But in our book, we put a lot of emphasis on this remedy as a way of dealing with the issue of a right without a remedy in the British Columbia variation legislation.
Wow, that is a very memorable matter. Well, I guess everyone will just have to read it in the book. We will link the book. These are things that movies are made out of. That's just so complicated. The family dynamics. Wow, Mark, that is a very complicated matter. Thanks for sharing that with us. In addition, to close this off, I'm just curious, would you recommend that our member community undertakes a very large book project like this? If so, why? And if not, why not?
I think that if you are going to be undertaking a project like this, you need to know why you're doing it and you need to feel really committed to it because it is a lot of work. It was a lot to balance with our own practice. Mark and I run the litigation part of our estate group. And in addition to all of the non-billable tasks that we have our own practices. And so it was a big commitment. But I'm so proud that we were able to complete it. And I really am committed to continuing legal education. I think it's very important, and I volunteer a lot of my time to various organizations here for that purpose. And so this seemed like the natural progression, although it is it is a lot more work than doing a presentation or contributing to a chapter of a book here. So writing the whole thing is a big job, but I would recommend it if this is in your area of interest.
And did it help you to mentor, as you said earlier, your young attorneys? Did they come out of this kind of feeling better about their experience and education?
Mark? Definitely, that was an important part of the initiative to really engage our lawyers. It permitted us very focused training, but also encouraged them to be credentialed in a way that otherwise they wouldn't have that opportunity. So we saw it as an important part of the growth of our practice group and really a commitment to younger lawyers in their practices.
There is one other piece to this, which is while we were working on this, we had regular meetings every week to discuss a chapter or to discuss a piece of the book. And we used that not just to improve the book and to get more diverse input into it, but also as training for all of us to improve our own skills as lawyers here at Clark Wilson. So we had that added benefit of basically studying every week as we went through the course of this.
Well, beyond the firm, it just seems to be such a large contribution to the practice in British Columbia. So it will continue to educate so many others. We will link the website of the book to this podcast so that everyone who's interested can review it. And then we'll ask members to contact you directly if they're looking for some guidance and mentorship on how to write such a complicated book. So thank you. Thank you for your time. and the education. Those matters are fascinating.
Thank you for your time, and we're happy to answer any questions. If anybody wants to talk about the book or about estates generally here in British Columbia, please reach out.
Thank you.
And that concludes our recording. Thank you for joining us today. You can find this and many other episodes at scgglobalspin.com.